India Legal presents Courts Roundup.
Hello, I'm Hishay and you're watching Courts Roundup. In this program, we bring to you the latest legal news, biggest and most significant hearings and judgments of the day. We also bring the details of court proceedings. Before we begin, here's the headlines. Supreme Court quashes NLSIU's planned NLAT exams, says CLAT will remain the only selection exam to be held on September 28th. On Shaheen Bagh protest, Supreme Court reserves order on balance between right to protest and other public rights. Review plea filed on PMCares Fund in Supreme Court against dismissal of PIL for transferring funds to NDRF. Delhi High Court rules no listing of a writ petition relating to an industrial dispute unless it discloses exceptional circumstances, says dispute to be resolved in Industrial Tribunal.
India Legal presents Courts Roundup.
The Supreme Court has quashed the notification on a conduct of the Bangalore-based National Law School of India University's separate entrance exam called the National Law Aptitude Exam or NLAT 2020. The top court ordered that this year the NLSIU will have to conduct its admission to its courses through the Common Law Admission Test or CLAT. According to court, CLAT 2020 will have to be held on its scheduled date of September 28 and concluded that the conduct of CLAT 2020 should not be hindered by NLSIU in any manner. The Supreme Court has quashed the conduct of National Law School of India University Bangalore's separate entrance exam, the National Law Aptitude Exam 2020. The court ordered that NLSIU would have to conduct admissions to its courses this year through the Common Law Admission Test. The bench of Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah had reserved judgment in the matter on September 17th after giving the case an extensive hearing. Earlier, the court had allowed NLSIU to conduct the contentious NLAT. However, the apex court had held that the result would be declared subject to the decision of the court. The court had directed that CLAT 2020 be held on its scheduled date of September 28 in accordance with all the safety guidelines prescribed by the Union Ministry of Health and Family Welfare. The court further directed the result of CLAT 2020 are to be declared as early as possible to ensure that universities can start admission as soon as possible. Further, the court has directed that NLSIU be reinstated to the Secretariat of the NLU Consortium and that the Vice-Chancellor, Professor Sudhir Krishnaswamy, be given back his post of Secretary-Treasurer of the Consortium. NLSIU's move to conduct a separate entrance exam this year, owing to the delayed conduct of CLAT 2020, was challenged by former NLSIU Vice-Chancellor Professor Venkata Rao along with an aspirant parent. The court was urged to quash the September 3rd notification announcing the conduct of NLAT for NLSIU admission this year. Another prayer was made for quashing of NLSIU's notification regarding the technical requirements to write NLAT and for a direction to the university to accept students this year on the basis of CLAT scores. One of the central points of contention in the matter was NLSIU's unilateral decision to hold a separate exam whilst being part of the consortium, a society which had come to be formed primarily for the purpose of holding a common law entrance exam for admissions to NLUs. Bureau Report. The Supreme Court has reserved its judgment on the aspect of the need to balance the right to protect with the right of mobility by other people in the pleas which had sought an urgent direction for immediate disposal of Shaheen Bagh protesters or any other such sites amid the pandemic situation. A bench led by Justice S.K. Kaul orally remarked that the experimental which ensued in Shaheen Bagh called for a short order to be passed in light of what ensued. Whether successful or not, petitioner in-person advocate Amit Shaheen stated that such kind of protest must not take place in the future. He then highlighted that there was a Chakka Jam in Haryana on 20th of September. Advocate Mahmood Pracha, appearing for one of the interveners, submitted that the most crucial aspect that person from ruling party went there and right to protest has to be balanced in a democracy. Solicitor General Tushar Mehta argued that the right to protest was a fundamental right, albeit with reasonable restriction. The petition filed by a practicing lawyer in the Supreme Court, Ashutosh Dubey, however, says that protesters can continue their protest after such threat of coronavirus is over. Due to the growing threat of the disease and increase in the number of deaths, and the Health Ministry has advised everyone to avoid going out in the crowd and work from home. In related news, a PIL was filed in the Supreme Court seeking urgent direction from immediate disposal of Shaheen Bagh protesters or any other such sites in view of coronavirus threat on 20th of September. The Supreme Court has been moved in a review petition as against its August 18 judgment disposing of PIL filed by the Centre for Public Interest Litigation seeking to transfer the funds from PMCares to National Disaster Response Fund created under the National Disaster Management Act 2005. Dismissing the plea, the court had held that there was no need for a fresh national disaster relief plan for COVID-19 and that the minimum standards of relief as issued under the Disaster Management Act prior to COVID-19 were enough. The bench also clarified that the centre will be free to transfer the funds to NDRF as it deems appropriate and that individuals are at liberty to donate to NDRF. The review plea has been filed by petitioner in person Mukesh Kumar, an intervener in the original proceeding. Plea held that not only PMCares Fund but also creation of the NDRF and CMRF are also unconstitutional unless the same are created by way of enactment of the Parliament, making thereby the Prime Minister, other ministers as trustees therein, and similarly unless Chief Minister is statutory made trustee of the CMRF for each state. A petition has been moved in the Supreme Court calling for laws relating to succession and inheritance to be gender neutral, religion neutral and uniform for all citizens while invoking Articles 14, 15, 21 and 44 of the Constitution and international conventions. The plea filed through advocate Ashwini Kumar Upadhyay argues that the varying law on succession and inheritance which presently prevail are discriminatory against women. The petition avers that uniformity in succession and inheritance is not only necessary to secure gender justice, gender equality and dignity of women, but also essential to promote fraternity, unity and national integration, but Centre has not taken any steps in this regard till date. Therefore, a blatant form of discrimination, that is the prejudice in the succession and inheritance based on gender and religion, is continuing. The plea notes that the Hindus, Buddhists, Sikhs and Jains are governed by the Hindu Succession Act 1956, whereas Christians, Parsis and Jews are governed by the Indian Succession Act 1925. Muslims are governed by the Sharia Act, in which the share of female heir is half of the male heirs. It is further stated, the petition makes the following prayers: to declare that the discriminatory grounds of succession and inheritance are violative of Article 14, 15 and 21 of the Constitution, issues direction to frame gender-neutral, religion-neutral, uniform guidelines of succession and inheritance for all Indian citizens. The plea also cites examples of uniform civil code as it exists in some parts of India and abroad. Dhaka Foundation of India, which is at the center of controversy in the Supreme Court case against Sudarshan News program on UPSC Jihad, has sought to intervene in the petition, stating that the channel has been cherry-picking facts from publicly accessible documents on the internet and drawing unsustainable interference therefrom. The intervention application filed by advocate on record Mrigang Prabhakar clarifies the concept of jihad debut, rebuts unfounded allegation by Sudarshan TV and highlights the hateful antecedent of Sudarshan TV. ZFI has stated that Sudarshan News has to provide strict proof for all claims made against the NGO, stating that the channel has put the cart before the horse and presumed that the donors of ZFI are somehow linked to terrorist activities. The organization has claimed that it has revealed nothing but a deep-seated malice against Muslims. The Delhi High Court has held that a writ petition relating to an industrial dispute shall not be listed unless it discloses exceptional circumstances in the symposium and in its opening paragraph. Justice J.R. Midha was hearing the writ petition's challenge to the retrenchment of 297 employees by the Press Trust of India on 29th of September 2018. The petitioners sought the quashing of the retrenchment notices, their reinstatement with back wages and consequential benefits. The preliminary issue was whether the writ petition should be entertained in view of the statutory remedy available to the retrenched employees under the Industrial Disputes Act. If this writ petition with such complicated question of fact and law is entertained, then on what ground a writ petition of a simple retrenchment or termination can be declined? Most of the retrenchment cases are simpler than the present case, but the jurisdiction is not exercised as the law is clear and well settled that the rights under the Industrial Disputes Act have to be placed before the Industrial Tribunal. The bench opened. Asserting that the right to a decent funeral can also be traced in Article 25 of the Constitution of India, the Calcutta High Court ruled that the immediate family members of COVID-19 victims be permitted to perform the funeral rites of the deceased subjects to them following certain precautionary guidelines to minimize the risk of them becoming infected by the deadly virus. The court was also on the firm view that the right of the family of a COVID-19 victim to perform the last rites before the cremation burial of the deceased person is a right akin to fundamental rights within the meaning of Article 21 of the Constitution of India. Chief Justice Totathil B. Radhakrishnan and Justice Arijit Banerjee were pronouncing the judgment on a PIL raising the following two issues. Inter alia, the four issues are as follows. Number one, the human remain dead bodies of person inflicted with COVID-19 are being disposed of by the administration unceremoniously and in an undignified manner without showing even a semblance of respect to the mortal remains. 2. Relatives and friends of person admitted to hospitals with COVID-19 or person who have contracted the disease whilst in hospital having passed away are not being permitted to have at least a look at or to pay last respect to the mortal remains of the dead person and to perform the last rite. The division bench opened that there is no scope for doubt anymore that the right to life enshrined in Article 21 includes the right to life and dignity. Agreeing with the submission of the petitioner that living with dignity includes not only the dignity of a person when he is alive, but also the dignity following his death. Court said that we unhesitatingly holds that the mortal remains of the deceased person must be treated with care, respect and dignity and have to be disposed of by burial or burning according to the religion. And now it's time for a short break. We'll be right back.
India Legal presents Courts Roundup. India Legal presents Courts Roundup.
And welcome back. The Kerala High Court has passed an order not to allow use of any social media platform by a rape accused until the investigation gets over. This order has been given by Justice P.V. Kunikrishnan while hearing a bail petition of a man accused of raping a girl. The court has observed that all methods or conditions like asking to surrender the passport or appear before an investigation officer while granting bail to an accused is a crime is fairly common, but times have changed now. Mohammad Sifas, the accused in the case, took advantage of his relationship with the victim to take her to a resort in Chennai on December on the pretext of giving her a birthday gift. He then raped her. Thereafter, he had taken nude photos of the victim and threatened her not to tell anyone about this or he will post her pictures on social media. Not only that, he further used this as his tool of getting his desire fulfilled and raped the girl 6 more times. Though the girl obeyed his command, he posted her pictures on Facebook and demanded 1 lakh rupees from her to delete those pictures. The prosecution has requested to the court that the girl is in fear that if the accused is released on bail, he may circulate the photos on social media again. Under such circumstances, there was nothing wrong in imposing a condition that the accused shall not use social media platform. The court has allowed the bail in view of the principle that bail is the rule and present situation of COVID-19 pandemic. Now, we are now joined by Advocate Shivam Sharma. Shivam, can you update us on the details?
Yes, in this case, the court has said that considering the special facts and circumstances of the case, if bail is granted, why not there be a condition in this bail order directing the petitioner not to be used social media like Facebook, WhatsApp and Twitter, Instagram, etc. if the case is finally concluded. court further said that hazards will not fall down if a condition is imposed in a bail order restraining the accused in a rape case is using social media, especially when it is to protect the victim from girls' privacy. Therefore, the petitioner shall not use social media like the court said therefore the petitioner shall not use social media like Facebook, WhatsApp, Instagram, etc. till the investigation is completed. If any final report is filed against the petitioner in this case, after investigation and the court concerned took cognizance of the same, the above condition will continue till the trial in that case is over. Yes.
Thank you, Shivam. The Kerala High Court has directed a school in Ernakulam to not expel any students from attending online classes merely on account of their incapability to pay the full school fees. While taking into consideration the COVID-19 pandemic scenario, the order passed by Justice Devan Ramachandra reads the High Court further directed the petitioners to provide a time frame within which they would be able to pay the fees on the next date of hearing. Advocate S. Nirmal, the Standing Counsel for the Central Board of Secondary Education, informed the court that expulsion of the students for want of fees was not encouraged. He added that he would obtain instructions in the matter and apprise the court about the same of the next date of hearing. The matter will now be taken up on September 23rd. In a small victory for investors in the ill-fated Popular Finance Fund, the Kerala High Court has allowed the state government to approach the union government to demand for CBI inquiry into the dealing of the group. Popular Finance, headquartered in Panthamithalita, has been in the business of extending gold loans and receiving deposits from the public since 1965. It is a family-owned business. The group's dealing came under the scanner last month after investors raised complaints about not receiving returns on investment. Investors were lured by the promise of the monthly interest of 18%, which was found to be nothing but amount from other deposits. Aggrieved investors group and individuals filed pleas in the High Court seeking for the attachment of the Popular Group's properties as well as a probe by the CBI. Justice V.G. Arun has admitted the pleas and granted interim relief in the matter yesterday after the state government submitted that it was not averse to a CBI probe. Justice Arun allowed the state government to approach the centre seeking a CBI probe and also directed the group's various properties to be attached pending further orders by the authority that would oversee the investigation. While the former is a state legislation, the latter is a central legislation that contains specific provisions against finance frauds of the kind run by Popular Finance. Directing the service of notice upon the respondent lodged in prison, Justice Arun indicated that the matter may be posted early next month for the evaluation of the status of investigation and action taken. Thank you for joining us. For more updates, stay tuned to APN News.
India Legal presents Courts Roundup.